So let's start first with what are you entitled to claim when you get in a car accident. There are typically two types of claims that you can pursue when in a car accident in Michigan. The first claim you're likely entitled to is a claim for no-fault benefits. This is sometimes called PIP. It's also called first-party benefits. So no-fault, PIP, first-party, it's all kind of interchangeable, and I'm going to use all of that throughout this video, and throughout your case you're going to hear those terms used interchangeably. No-fault, PIP, and first-party benefits are all the same, and they essentially mean your economic claims from your car accident. So in short, your no-fault claims are essentially economic damages with your own insurance company. The economic damages you're entitled to include payment of medical bills, payment of attendant care, payment of replacement services, and payment of lost wages. And I'm going to go through each of these quickly in a second. Before we can start figuring out what we can claim, we need to understand the first step to starting the process, which is we need to figure out and determine what is the correct insurance company. What is the correct PIP insurance company? If you do not file a claim with the correct insurance company within a year of the accident, you will be forever barred from making a claim for no-fault benefits. Also, if you try filing a claim with the wrong insurer, they will not pay and they will win any lawsuits you file. So it is very important to identify the proper insurer as soon as possible. Now, before the changes to the No Fault Act in 2019, the major changes that I'm sure you all heard of on the news, it was very confusing to identify the proper insurer. But as the law currently stands, it's much easier. For most of you, if you or your spouse have purchased car insurance, that insurer is going to be responsible for PIP benefits. So if you bought insurance and you have an insurance policy, that is going to be your PIP insurer, and it's a very straightforward process. If you or your spouse do not have your own insurance, then you must claim through a family member who you live with that has car insurance. So if you're living with a parent who has insurance, or an aunt or a grandmother, uncle, whatever it is if they're related to you and they have insurance, you must file a claim through their insurance. If you don't, and the insurance and you try to process a first-party claim, it's going to get denied. And we've had situations where people did not want, where our clients did not want their cousin's insurance to go up, their premiums to go up, so they did not mention that their cousin had insurance. And we went through a case, and the insurance company conducted discovery and found out that the cousin had insurance, and then the case ended up being dismissed because our client was not forthright and did not tell us that their cousin had insurance. So it's very important that you identify if there is a family member in the household that has insurance. So again, the order of priority is that first you must go to your own insurance company, and then if you do not have your own insurance, then to the insurer of a resident relative. If none of that applies, then you must seek insurance from the Michigan Assigned Claims Plan. The Michigan Assigned Claims Plan, which we call MACP for short, is a state-run program that will assign you an insurance company for your claim if you don't have any coverage that applies. And it can be any participating insurance company that is assigned to you. AAA, Nationwide, Citizens, Farmers. It's a completely random draw that the MACP selects. One caveat is that if you were driving your own car in the accident and you do not have insurance, you cannot apply to the MACP. You're essentially barred from benefits if you're driving your own uninsured car. And there's a few other more complicated scenarios which I will not get into right now. If you have this scenario, then contact us and we'll tell you what the plan is. But if you were in a Lyft, an Uber, you were in a bus, you're from out of state, or you were traveling out of state when the accident happened, there's a different analysis. But just in general, you should know your own insurer first, then resident relatives, and then MACP. And the last thing on this topic is, just to be clear, You cannot claim PIP benefits from the at-fault driver's insurance company. So the person who hit you has nothing to do with no-fault benefits. With your first-party case, the person who hit you has nothing to do with that. That is a separate claim. It's called a bodily injury claim, which we'll discuss later, but it has nothing to do with your no-fault benefits. In Michigan, we have a system where your own insurance, the no-fault carrier, will pay for all of your economic damages. Now, let's get back to the various benefits that you're allowed to claim in a PIP case. So the first thing I mentioned is that your no-fault insurer is required to pay for all accident-related medical bills. Now, in theory, that sounds simple, but in actuality, it's not that simple. First off, the car insurance will not pay for medical bills if you have a coordinated policy or you opted out of medical coverage when buying your no-fault policy. And this is something that is very common after the amendments to the No Fault Act in 2019. A lot of you have opted out of your medical coverage, and some of you may not even have known this, but you chose elected a very a cheaper policy from the auto insurer that requires you to go through your health insurance. If that is the case, then you may not have a PIP case. You may not have a first party case because a lot of the benefits are covered by that medical clause. Second, the insurance company is not responsible for paying bills that are not related to your accident. So of course, the insurance companies are going to try to say that many of your bills, or all of your bills potentially, are not related to the accident. And they do this because their goal is to not pay. The insurance company only needs to pay for the services that are reasonable and necessary for your accident-related injuries. So just because you've incurred these bills doesn't mean they're going to get paid, and that's part of the reason why you need an attorney to navigate through this. Further, if the PIP insurance company believes that your doctor is charging too much for their services, they may also decline payment or only pay a portion of the bills, like it's a very small amount, because again, ultimately it is the insurance company's goal to pay as little as possible. That's how they make their money, and I'm going to discuss that later. The next benefit you may be entitled to is replacement services. If you need help around the house with cooking, cleaning, laundry, mowing the lawn, etc., you can claim something called replacement services from your PIP insurer. This is a benefit where the insurance company will pay you $20 per day for help around the house. That $20 a day was established in the 1970s and has not changed since. It's a very low amount and quite unfair, but it's something that you should be claiming and you should be keeping track of. Replacement services are a benefit you're entitled to for 3 years, and then it ends. And in order to get replacement services, you do need to get a prescription or a script from a doctor saying that you need these services, and you need to keep track of these on a calendar or a log, and we will provide you with these logs. A family member can provide these replacement services to you. It doesn't need to be someone from the outside. So you know, if you have a parent or a sibling that is going to be providing the care or the services, that's perfectly fine, just as long as they keep track. This is a benefit that you're entitled to, but the insurance company will often not pay, or they'll pay for a certain time and stop and then force us to file suit. The insurance company is going to argue that you don't really need the help around the house, or that the reason you need help is because of an unrelated issue. I should note that replacement services are different from attendant care. Some of you already know about what attendant care is and have heard of replacement services. They're both a benefit where someone is taking care of you essentially, or helping you, but they are two different types of benefits, and I'm going to get into attendant care later. That is more of when someone is taking care of your personal needs, and it's a much more valuable benefit because it's reimbursed at a higher rate. The next benefit that you're entitled to is that you may be entitled to is wage loss. If you were working at the time of the accident and when unable to work after because of injuries related to the accident, you may be eligible for work loss benefits from your PIP insurer. Wage loss benefits are paid at 85% of your income based on your last month of work. In order to claim wage loss, you will need to submit tax returns and pay stubs as proof of income. You also need an order from a physician stating you are disabled from work. Like with replacement services, this is only a 3-year benefit, and there is a statutory cap on how much you can claim. If you are self-employed, the calculation of your wage loss can become very complicated, and it's something that you should discuss with us as soon as possible. And then the final benefit I want to discuss that's part of your first party claim is attendant care, which is technically part of your medical coverage. And if you don't have medical coverage, then you can't claim attendant care. But I like to think of attendant care as a separate benefit because it is an expense that can be paid directly to you and not to the doctors. Is sort of a medical bill that's paid directly to you instead of to a medical provider. So what is attendant care? Attendant care is essentially getting help with your personal care such as putting on your clothes, helping you in and out of the bed, helping you in and out of the couch, helping you walk, doing your hair, giving you meds, feeding you, supervising you so you don't fall, things like that. This is a very valuable benefit in PIP cases, and it is, I would say in fact, that it is the most valuable benefit to injured plaintiffs from a monetary standpoint. And the reason the attendant care is so valuable from a monetary standpoint is that it is reimbursed on an hourly basis. So if you recall, I said that replacement services are paid at $20 per day. Attendant care, conversely, is reimbursed at around $12 an hour, not per day, an hour. If it's provided by an unskilled person such as a family member, but if it's provided by a company, which some of you will need a company to provide attendant care, it's reimbursed at a much higher rate. So just an example of why this is a valuable benefit. If your doctor prescribes you 8 hours a day of attendant care, that's around $2,800 per month in attendant care benefits, or $33,000 a year. And so it can really add up depending on the number of hours you are prescribed. And unlike with replacement services, there's no 3-year limitation to this benefit. As long as your doctor is writing prescriptions for the attendant care and you have the coverage in your policy, you can get attendant care. For example, I have a current client who's been getting attendant care since 1986. I have other ones from the 90s that are still getting attendant care. And so, it is something that you can continue if you actually need it, if a physician actually prescribes it. You can't just claim attendant care without the medical necessity that is justified by a physician's script. It should be noted that after the 2019 law changes, there is now a restriction that family members can only provide 8 hours a day of attendant care, and that's whether they provide directly or through a company. So if you have a script for 16 hours of attendant care, you can only have a family member do 8 hours. The rest is going to have to come from someone else, such as a company. As you can see, attendant care is a very significant benefit, but it's also one that's extremely difficult to get paid. Insurance companies hate paying attendant care. They will very rarely pay it voluntarily. It's a very expensive benefit, and they have found a lot of fraud in attendant care. Unfortunately, there's some plaintiffs who claim family members are taking care of them, and then they bill the insurance company, but then the insurance company later finds out that the family member was never actually providing the care. They have surveillance video of the family member or the plaintiff doing stuff where they're not in the presence of each other. The family member is on a cruise somewhere. The plaintiff is out playing basketball when they say that they need help with just about every task. They can't get in and out of their couch. They can't put on their clothes, and yet they're out playing basketball or shoveling snow. So insurance companies are inherently skeptical about attendant care, and it is a very difficult benefit to get paid. If you are going to pursue attendant care, you need to do it very diligently and carefully and through our guidance. There are certain other PIP benefits that you may be eligible for as well, such as medical mileage and home mods. If you believe that you qualify for any of those, please talk to us or the handling attorney and paralegals in our office, and we can get you more information. But that's all I want to discuss about the PIP cases. Now let's move on to your third-party cases. So, as I told you earlier, there are two types of cases that you may be entitled to when you get into an accident. I already discussed the no-fault case. The other type of case is the bodily injury claim, otherwise known as the third-party case. The third-party case is for what we call non-economic damages. This is your compensation for your pain and suffering. Someone else, the at-fault driver, caused your injuries, and therefore they owe you for the pain and suffering that they caused. Third-party cases is where most of your money comes from, like the money that you put in your pocket. Unlike with the first-party case, third-party cases, the money that you recover is yours, minus the attorney fee, of course. In the first-party case, unless you have a wage loss claim, the money technically is not supposed to be for you. And a lot of clients oftentimes don't understand at the end of the case what happened to the money or why they didn't get X amount of dollars when the settlement was fairly significant. In no-fault cases, the money cannot be claimed for you. It is a claim for medical bills and for people who helped you, unless you have a wage loss claim. Third-party cases is where the money comes to you. Again, first-party cases are not designed to compensate you. Third-party cases are. In order to have a third-party case, we need to prove that the other driver was at fault for the accident and that you have sustained a serious impairment of a body function as a result of the accident. Now, serious impairment of a body function is a legal term that's in the statute that basically means that you have a very serious injury that is supported with medical records and medical imaging. And you have to be able to show that your life has been turned upside down as a result of the accidents. You have to be able to show that before the accident you were healthy, you lived a very productive, a very happy life, and then since the accident you can't do a lot of what you were able to do before the accident. Your deposition testimony is very important for proving these points. So you have the aspect where your medical records has to show you have serious injuries, and it's not from pre-existing injuries but from new injuries, or there has to be an aggravation of your prior injuries, and you have to show that your life has completely declined as a result of the accident. If you cannot show these things, your case will get dismissed by the judge. It is a very high standard to meet, and a lot of cases do get dismissed because the plaintiffs are unable to show that their life has changed. I've seen cases get dismissed because the plaintiff stated that the only thing they can't do since the accident was they can't play golf. They had a passion for golf and they talked about it a lot. He talked about it a lot at his deposition. That is not sufficient to show a threshold injury. That is not sufficient enough to show what the law requires. You need to be able to show that you can't golf anymore and that you need help with laundry, cooking, cleaning, that you can't travel long distances, that you have issues working at your job, that you can't do social activities, all of that. You need to show all of that in order to have a viable third-party case. So the last thing about third-party cases, before I get into the million-dollar question, which is how much is my case worth, I wanted to discuss uninsured motorist coverage. So what happens if you get hit by a driver that does not have insurance, or if you had an accident where it was a hit and run? If you are in this situation and you have your own insurance policy and you purchased something called uninsured motorist coverage, then you will still have a third-party case. It will just come from your own insurance company instead of the at-fault driver's insurance company. So in other words, If you were in an accident with someone who was uninsured, or they took off after the accident, your own insurance company will take care of the third-party benefits. Now, in order for you to qualify for uninsured motorist coverage, most policies require a few things. First, you have to call the police within 24 hours of your accident, and there must be contact between the uninsured vehicle and you. You can't say that someone swerved into your lane and forced you to turn the wheel and then you went into a median and that's how the accident happened. If there was no actual hit between the uninsured vehicle and your vehicle, you can't make a claim.